All rise. Ladies and gentlemen, the Supreme Court of Alabama, hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Please be seated. Welcome this morning. Will the clerk please call the docket?
In case number SC 2023-0395, Ex parte Triad of Alabama, LLC, doing business as Flowers Hospital. Arguing for the petitioner, the Honorable Ed Haddon. In arguing for the respondent, the Honorable Calvin Whaley.
Mr. Haddon, you may approach the lectern and begin.
Thank you, Your Honor. May it please the court, my name is Ed Haddon, and I represent Flowers Hospital. On September 22nd, 2021, Bonseal Askew had COVID. She went to Flowers Hospital to get treatment for her COVID in infusion therapy. She entered through a door. The door had been there for several years, but during the pandemic, Flowers decided that they were going to route COVID patients through that door and non-COVID patients through a separate entrance to separate the two populations. She went in through the door, she got her COVID treatment. Then I want to read from the plaintiff's complaint, Appendix C, Second Amendment Complaint, paragraph 19. At approximately 2:35 p.m., her treatment was completed, and Mrs. Askew was released and directed to proceed unassisted out the same infusion entry service door. When she walked out the door, she tripped, she fell, she was injured. She brought two claims, a negligence claim and a wantonness claim. Flowers Hospital asserted an affirmative defense, the Coronavirus Immunity Act of 2021, on the negligence claim. That act came out of the pandemic. Businesses were shut down, hospitals were straining to treat all the COVID patients. They came to Governor Ivey and the legislature for help. At first, in May of 2020, the legislature couldn't even convene, so they got an executive order from Governor Ivey that provided some limited protections for certain COVID activities. But by February of 2021, the legislature could convene. And so the legislature enacted the Coronavirus Act. It provided a little bit broader protections. I'd like to point the court's attention to 792 that says, notwithstanding any other provision of law, a covered entity, which includes a hospital like Flowers, shall not be liable for any damages or injury as a result of or in connection with a health emergency claim. And a health emergency claim is defined in section 791. A health emergency claim is any claim that arises from or is related to coronavirus. It's not limited to certain activities. Instead, any claim that arises from or is related to coronavirus. Well, that's not unfamiliar language. Arises from, if a claim arises from, then we look at the elements, duty, breach, causation, damages, and we look at specifically proximate causation. Remember, Flowers Hospital is alleged to have directed Mrs. Askew to go through that specific door where she fell, where the defect was. They directed her to that defect. That's why she fell. We think that arises from. Now, related to is broader than arises from. Related to means, well, what was the purpose of her visit? What was the purpose of her going through that door? Well, the purpose of her visit was to get COVID treatment. And the purpose of her going through that door was because she had COVID, they routed her through that door, in their words, directed her through that door to keep her isolated from non-COVID patients. So, Your Honor, our position is that under arising from and related to, we qualify under both because she was there for COVID, she was proximately caused to have her injury because she had COVID, was directed through that door to that defect because she had COVID, and so we think that both arises from and is related to coronavirus. Now, we think the structure of the Act also reinforces what we're talking about. If you look at the last part here, it says the term, and that's health emergency claim, includes, but is not limited to, any cause of action that relates in any manner to A, and there's a B. Okay? In the executive order, the immunity was limited to two activities, transmission and response. In the Act, it says the term includes these activities, but is not limited to. In fact, it goes up to the general test, any claim that arises from related to coronavirus. It doesn't have to be limited to activities, anything. And so here we have her claim that she has a premises liability claim. I tripped and fell on a defect. We allege that to be true at this time. We'll agree with that for purposes of this motion. And they say, okay, she fell because they directed her to that door. Okay, well, that's the proximate cause. And then the purpose, they directed her because she had COVID. If she did not have COVID, she would not have been directed to that defect. And so our position is that under the Act, under 792A and 791A13, arise from related to, we have immunity under this case for this negligence claim. Now, we agree that's broad immunity, no question about it. But the legislature had to balance several things. One, businesses not being able to make their mortgage or their payroll. Two, hospitals worried about, well, can we stay open? We're not sure how effective our treatments are. We think people are getting infected in the hospital. We need some help. Well, they didn't take away the wantonness claim. That continues to go forward. And they could have abolished negligence if they want to, like they did with the Workers' Comp Act. But instead, what they did is suspend it, basically, for a limited period of time, about 32 months, from March 13th, 2020, when the state of emergency came, until October 31st, 2022, when under Section 799 of the statute, this immunity sunsetted and went away.
Mr. Haddon?
Yes, Your Honor.
I want to pause you right there on the statutory interpretation argument, because you did just bring up a point. You've moved to dismiss based on immunity as to the negligence claim, right? But there's a wantonness claim still?
Yes, Your Honor. The wantonness claim will continue to go forward.
As to the petitioner? So one thing, maybe you can kind of help me think about this. As I understand immunity is not merely that your client wouldn't be liable, but that they wouldn't have to go through the litigation at all. That's what we often see in the context of state immunity or state agent immunity. Here, you're coming to us on a mandamus petition, on an immunity question, and regardless of whether we rule in your client's favor or not, if we rule in your client's favor, you're still going to have to litigate this wantonness claim below, correct?
That's correct.
So walk me through why we should be granting the writ of mandamus on immunity if there's still this claim residing below that you're going to have to litigate.
Right. I think, Your Honor, that good question. It goes to the difference, I think, between a permissive appeal, which was under Rule 5, which would say, okay, would it materially advance the ultimate termination of the whole litigation? Okay, and I don't think this would qualify under Rule 5 because of that. Under mandamus, however, you don't have to terminate. It could be one claim. For example, under workers' comp immunity, you can have one claim be out. Under state agent immunity, if you have a police officer who has state agent immunity and somebody else who doesn't, you can have one person go out on state agent immunity. And so with respect to mandamus, I think what the cases say is that you can look at immunity, even statutory immunity, not necessarily sovereign immunity or jurisdictional, but even statutory immunity, municipal immunity, state agent immunity that's individual to each individual person. And you can look at, well, did this person have malice? Did this person have bad faith? And you can look at individual persons and the way does that person have that particular statutory immunity. And you can do it by claim. And so, for example, we believe that this claim, here it's easy. We've got one hospital, one defendant, and we've got basically two claims.
Can you point us to some cases where you think you're on all fours with that idea in the mandamus context? You know, I was looking back at the Mestis case that we decided, and you know, there was an immunity question before us, but all of the claims against that petitioner had been resolved below, and so they were coming to us as to all of the claims against the petitioner. But Are there some other cases you would point us to that you feel like you're on all fours with?
Well, Your Honor, we'd be glad to file some in. If you'd allow us a week to give you a brief on it, we can clearly do that. But I think,
What we're trying to get at is,
yes, Your Honor.
are you even meeting the standard for relief under writ of mandamus? It appears you may have another remedy.
Well, Your Honor, actually, we don't, because the other remedy, I guess 2 points on that. Ex parte Hodge was a case that was decided several years ago with ex parte U.S. National Bank, when this court kind of restated the law on mandamus. And in that case, ex parte Hodge, they said that a permissive appeal, even if that's available, that does not keep you from getting mandamus. Because what they said is we have to look at the mandamus itself and see does that fit into the category. And here, ex parte Hodge would say, with a permissive appeal, you have to meet 3 elements. There's a question of law, a substantial difference of opinion, and it would materially advance the permissive appeal, materially advance the ultimate termination of litigation. And so this would not qualify for a Rule 5 permissive appeal. And so that would not be an available remedy. So the only remedy we have, just like you have in every other statutory immunity case, is mandamus. Further, we would suggest that mandamus, even in the federal arena, where mandamus is much more narrowly construed, I think there was a case called U.S. v. Cheney. They said that with respect to a novel question of law, they would grant mandamus, and this, of course, is a first impression case, grant mandamus to actually look at that. And I'll be glad to file that case in and indicate to the court that case in federal law. But with respect to mandamus here, we have no other adequate remedy because we can't go to a permissive appeal. With respect to a regular appeal, here we would say, Your Honor, in almost every immunity case, you have to get, is there enough facts to show that immunity applies? And here, we've, on a motion to strike, our petition, our affirmative defense has been stricken before we can even get there. But we do have some facts about the doorway and about Mrs. Askew and about Flowers Hospital response. Those facts are undisputed, and so we think we are ripe for a mandamus review. Further, is it a, in addition to do we have a clear legal right, is there a duty on the judge to rule for us? And we would say when the statute says the entity shall not be liable, that's a pretty strict duty on the trial judge, and he did not perform that duty. And so we would say under ex parte U.S. National Bank, when we have a novel question that hadn't been decided, that case, Justice Boland wrote for the court and said, yes, even when it's an undecided question, this court can take it on mandamus and decide it, and you can have a clear legal right based on the decision of this court. It doesn't have to be already decided. And based on ex parte Hodge, you can't go to a Rule 5 permissive appeal because you have this particular wantonness claim that would continue in the case. Yes, Your Honor. Yes, Your Honor. That's correct. So we think, Your Honor, that if you look at the mandamus categories and you say, okay, immunity, that this court has granted immunity in numerous cases on mandamus, on immunity over and over again. And this case, in the statute, it calls it immunity several times. And there are 2 types of immunity. One is constitutional immunity that can save you from litigation and from liability. We understand that. However, even in those cases, you still have to have enough facts to say, does it apply? For example, in Ex parte Cooper, a case that was before this court earlier this year, the director of the Department of Transportation, he was up here claiming that he was immune as part of the state. Well, in order to find out if that was true, we had to have a lot of facts to be gathered in order to come to the court. And so he had, in fact, a preliminary injunction mini-trial before he came there. And even with that, in Ex parte Cooper, Justice Mitchell, that claim was gone against him but there's still a inverse condemnation claim that will be tried, okay? And so that can go forward, even though this court decided immunity. Now, that was on a injunction appeal and not a mandamus, but nonetheless, this court all the time could have cases where you have multiple defendants who qualify in different ways. Sometimes immunity applies, sometimes it doesn't. But the question on mandamus has historically been, is this an immunity issue? And if it's an immunity issue, and if it's a novel issue under Ex parte U.S. National Bank, this court can address it, and this court can resolve that novel issue for a lot of cases around the state that are looking to what do these statutes mean.
Mr. Haddon, I want to give you kind of a fact scenario. Let's assume that Ms. Askew was suffering from anaphylactic shock. And so she shows up and she's not paying attention to anything. She just goes in that door. And the staff sees that she's got a problem and they treat her and she leaves out that door. What's the result of the case?
Okay. In that case, here's how I think we would analyze that case, Your Honor. First of all, we look for the term arises from. In that case, I don't think there's any question it does not arise from in your hypothetical, because she doesn't have COVID, she's not going there for COVID treatment, and they did not direct her through that door to get COVID treatment. And because they did not direct her through that door, there's no proximate cause, and so that element doesn't arise from it.
Well,
so next you
go ahead.
Go to related to. What is the purpose of her visit? Okay, the purpose of her visit was not to get COVID treatment, and that she was not directed to that door because she was a COVID patient.
Okay. Assume for a second that she just shows up and she trips in the parking lot.
Okay, well, I would say in your first hypothetical, I think that she would not be covered by immunity. In the second hypothetical, she just shows up in the parking lot and trips, and she is there for a non-COVID reason. She's not sent to that because she's COVID.
Let's assume she is there for a COVID reason, but she has not made it to get treatment yet.
Okay, so if, in the same scenario, she came in just like she did. She parked, she's going to the COVID door, and before the door there's a pothole, and she trips and falls in that pothole and breaks her ankle. Okay, in that case, Your Honor, I think she was invited in, premises liability. She was directed to go to that door, because that's the COVID door, and there was a danger in the landscape there. I think that would apply. If she's directed to go through that door because she has COVID, then I think that's proximate causation. I think that's arising from.
Mr. Haddon, your time has expired. Madam Clerk, would you add an appropriate amount of time for the other side that ran over here?
Thank you, sir.
Yes, and just to repeat what was said at the table there, they did some checking with the cameras before we started OA and found that these locations would work with our camera angles. So, Mr. Whaley?
Thank you. May it please the court, my name's Cal Whaley. I'm here on behalf of the plaintiff respondents, Von Sill and Don Askew. It is a privilege and an honor to be able to argue before you this morning. I want to start by focusing on the, Yes, Your Honor. I want to start by focusing on the heavy burden that's borne by Flowers Hospital in seeking this mandamus relief. Flowers Hospital has to establish a clear right to the relief requested, a clear right to immunity under either 792 or 794. There can be no reasonable basis for controversy regarding this right. It can't be doubtful. It can't be a stretch. And so we can't be stretching definitions and trying to shoehorn in a premises liability case when the plain language of the statute has nothing to do with that. Our lawsuit and our allegations are all about a hazardous ramp, 3 specific defects: no edge protection, no landing, and no guardrail. That's what our lawsuit's all about. These are long-standing hazards that have existed long before the pandemic. There's testimony from Flowers' CEO that patients and employees of the hospital were routinely routed through this specific entryway prior to the pandemic. And there's also testimony that no changes were made in any regard to this entrance before they started routing COVID patients. And so as a preliminary matter, we would say the use of this ramp doesn't really constitute the hospital's response to the virus. They were already using the ramp. This was already a long-standing hazard. But more to the point, there's been some talk about how, them directing us out the door is proximate cause of this accident. That's not what we allege in our lawsuit. The proximate cause of our injuries are these defects with the ramp. Our lawsuit is all about Flowers Hospital's general duties as a landowner in the state of Alabama towards an invitee, to make its premises reasonably safe and to warn of known hazards. That is what we allege. There's no allegation in our complaint relating to the infusion clinic. There's no allegation that we were woozy from the infusion or shouldn't have been released and that caused us to fall. If it were, I would say this is certainly a health emergency claim. But instead, no element of our cause of action is proved by reference to anything to do with COVID or the hospital's response thereto. Their focus is really twofold. They say it's related because the purpose of her visit was coronavirus and because where she fell was at that specifically designated COVID door, okay? And I want you to think, what do those two facts tell us about the claim, about the nature of the claim? They don't really tell us anything. As you pointed out, it could have just as easily been a pothole on the way in. It could have been a falling brick off the side of the building. She's still there for the same purpose, and she's still at that doorway. But there's no thought that the legislature intended to include unrelated premises cases like that within the definition of a health emergency claim. And that's why they tied that definition. They require some relation between the entity's response to the pandemic and the actual claim. The statute focuses on the nature of the claim. Does it arise from or relate to the coronavirus? And in that definition, they give specific illustrative examples of what they're talking about. Subsection A deals with contractions of the virus, exposures to the virus. Subsection B, which they didn't print, talks about efforts of the entity to prevent or delay the spread of coronavirus. And it talks specifically with more examples, claims related to testing, claims related to personal protective equipment, claims related to contact tracing. Any claim, any cause of action that's being described in these examples, at least one element of these causes of action is going to be proved with direct reference to COVID or a COVID response. Contrast this with what we have to prove. We prove a defect, a hazard on the premises, their duty to an invitee as a landowner, and the injuries resulting from that ramp. There's a lot of focus about this being a specially designated COVID-19 door and a treatment door to separate the patients. And the problem with that argument is we didn't sue them for that. We have no criticism about where they placed the infusion clinic. We didn't sue them for pointing at the door and telling us to go out that way. What we're suing them for is this ramp, which long predates the pandemic or the infusion clinic. It is the ramp that is the focus of our lawsuit. And this focus on this being a specially designated COVID door, and this is the spot where she fell, it almost implies that immunity emanates in rays from specific objects, and that's not how it works under the statute. Instead,
You get past any claim that arises from or is related to coronavirus. Ms. Askew was there because of coronavirus. She was there for treatment.
so I would say that there are immaterial factual connections, but as far as the claim itself, Ms. Askew's claim is a breach of the landowner duty which caused her injuries. And her claim really has no reference whatsoever to coronavirus or to the infusion clinic.
Just because she was there because of coronavirus. She would not otherwise have been there, correct?
Correct. And so I'd say, that's kind of that but-for causation that you can kind of back up and say that about, there's a lot of but-for causes for anything, but the claim doesn't arise from or relate to all of them. And I think a good example would be, let's say you've got a patient who just had a gallbladder surgery. He's been released, surgery went well, walking out a door marked surgical entrance, and slips in a puddle of water and falls. You would not say that premises liability, that slip and fall claim, arises from or relates to the gallbladder surgery or the efforts of the hospital to provide a surgical entrance for patients. Instead, that claim arises from or relates to the specific hazard.
I would throw out with you, since I've been on the court, and the court has taken a little bit of different tack, and I know y'all aren't suing for med mal, but saying that everything that happens in a hospital is not med mal. Again, somebody, like you said, they slip in a parking lot pothole. But wouldn't you concede that the hospital had a specific medical purpose to go through this doorway due to the pandemic?
I would, and I would say that decision, them picking that door, them putting the infusion center where they put it, That is not something that we have any criticism of. That's not something that we have.
But wouldn't you agree that that it was a medical decision? They wanted people to come through this door for a medical purpose, not just to be more convenient, like this is a more convenient way for sick people to get into the hospital, but for a specific medical purpose, being to avoid contamination from the virus.
Would. Yes, sir.
So then it would fit within, it would be a claim arising out or related to the coronavirus.
Well, I guess, and our point is, it's not that they picked that entrance. It's not that they said go through that door. That decision was an approximate cause of our accident. There should have been no problem with using that entrance. There should have been no problem with
I
going
understand that the decision wasn't, but it seems like Justice Wise, I think, was trying to say, and what sort of concerns at least me, maybe some other members of the court, is that, again, they had a specific medical purpose. You know, you go to in the abstract, you go to the hospital and you could either take the elevator or the stairs. You take the stairs, you slip and fall to go get medical treatment. In my opinion, that's not a med mal claim. It has nothing to do with it. But it seems like I'm struggling with, if they made the evidence is they made a medical decision. We all lived through this coronavirus where you had to go through all sorts of different hoops. But to go through this specific doorway and apparently no other because they didn't want this risk of contamination, the breadth of that statute seems compelling.
Well, and I would say that, the statute requires that decision, that medical decision that we're talking about. There has to be some causal relationship between that decision and the claim that we're bringing. And again, our claim does not criticize or go after that decision. We don't say that they should have routed us differently. We don't say that, they shouldn't have put the infusion clinic there. Our only criticism,
and I agree, y'all are saying, but they're saying the exact opposite. So why shouldn't the defense then be permitted to go forward instead of being stricken?
Well, so 792 focuses on health emergency claims that result from an act or omission. So there's also that causal connection. It's not just the fact that they were engaged in COVID operations and therefore should be, have blanket immunity for any premises liability because that's what they've got going on in that entrance. It's that there has to be some result between the act or omission of the healthcare provider and the claim that's being brought.
But then you've got the term includes, but is not limited to. I mean, is this an overly broad statute? Perhaps, I don't know. I'm not in the legislature. It's not my decision. But what we are left with is what appears to be a very, very broad statute.
I agree it's broad and it uses broad language, but it's also true that immunity statutes are to be strictly construed. And the fact that it's not limited to these examples, that you should still have claims that are sufficiently similar to the illustrative examples in the statute.
Let me ask you this. When you talked about, I think you said something, the CEO Flowers testified that personnel used this entrance, but I think you also said that patients used that entrance too. Was that a rare occasion? Did that happen frequently?
He testified that routinely both patients and employees used that specific entryway prior to the pandemic.
So do you have any evidence, and I apologize that I can't recall this off the top of my head, that non-COVID patients used that entrance during this time period too?
During this time period, no ma'am. It's our understanding that they didn't.
Okay.
That's right.
I want to maybe go, something else just troubled me about this case is the fact that the trial court struck this affirmative defense and didn't have a hearing, and we don't really have a detailed order. Does that bother you all at all? I mean, if we just decide to send it back to simply say you didn't hold a hearing and you should have, because we don't really know exactly what the rationale for striking that defense was, and that just troubles me, and I didn't know if you had an answer to why the court wouldn't at least give the other side a chance to flesh it out like we're doing today, or at least give us an order so we can know exactly why they would strike this defense, which seems somewhat rational to me.
Okay. I don't know his specific reasons for not issuing a written order on that issue.
The fact they didn't have a hearing, I mean, if we sent it back, would that be appropriate to have a hearing to figure out exactly what the trial court's thought process was? Because we really don't know.
I believe a hearing would be appropriate, but I think it is also a question of law, and I think it was within the trial court's province to say, this clearly just on the plain language of the statute and what's intended by the legislature, This doesn't fit. This is a stretch, this premises liability claim. And I'd also point to, if you look at Section 793, which we both concede does not apply to this claim, but Section 793 specifically mentions premises liability. It specifically talks about premises liability, and it also goes and gives a procedure of proof. The claimant under 793 has to, with clear and convincing evidence, show that a hospital failed to comply with an applicable public health guidance. Okay? So it's not that they didn't think about premises liability or just assumed that it would be included in this broad definition. They did specifically mention premises liability and deal with it in a separate section. They did not deal with it here. And I would say, claims about testing, claims about PPE, claims about contraction of the virus, these all directly relate to a COVID-related action, and they are just completely different in kind from a premises liability case regarding a long-standing trip hazard that predated the pandemic. And again, our allegations about the breach and what caused this incident is not that they picked that door or sent us through that doorway. It is all about the ramp. It's all about, and there's no allegation that the infusion or the door or any of their COVID-related actions played any causal role whatsoever in this accident.
Let's talk about the procedural aspect about this being a writ of mandamus. Why is this not proper for mandamus relief?
So I would say for two reasons. One, which I addressed at the beginning, the clear legal right. I would say, if anything, it would be hard for them to say that this is so clear that premises liability is captured by this, that there can just be no room for debate on the issue. I don't think they can make that showing. But number two, as Justice Bryan pointed out, it is clear that there's the potential for a regular appeal. There is another adequate remedy. They are still going to trial no matter what. And all the rationales about why usually immunity issues are appropriate for mandamus are all about sparing the person who's supposed to have immunity from the expense and the hassle of going through the trial. And they're usually done early, and it's to completely dispose of that. As the court pointed out, the case cited by them disposed of all the claims of the particular nurse defendant at issue in Mestis. In this case, there's two plaintiffs and one defendant, but it's the same parties that are going to be going to trial no matter what. And I also want to point out in the legislative findings for this statute, it says that the legislature intended to provide protections for businesses that reasonably attempt to comply with applicable public health guidance. There's no blanket immunity for all premises cases for anything having to do with a patient on premises for COVID treatment. And if they wanted to do that, the legislature could have. They could have said, we're not going to have premises liability against hospitals during this state of emergency. Hospitals are too strained and they just can't do it. But that's not how they did it. Instead, they focused on the nature of the claim, and they said the claim.
Mr. Whaley, to follow up on the point that was just made and that Mr. Haddon argued earlier in response to Justice Mitchell about, to an extent, I don't want to put words in Mr. Haddon's mouth, but he gets a second chance to get back up here. But we generally don't piecemeal a mandamus because apparently you are right. It'd still go back, I suppose, on the wantonness, these other claims, and that's an issue. Mr. Haddon argued, at least in part, that we should peg it into like an exception, being that this is a novel issue. I understand it's a new statute. Do you think it's a novel issue? I would submit just because something's a new statute doesn't necessarily equate with it being novel, but do you agree with him or disagree that this is a novel issue?
Certainly we don't have any authorities interpreting this specific statute, and it's new, like you said. So in that respect, it is certainly a novel issue. But as far as determining what a claim arises from or relates to, that's an old question in the law. That's something that we've been figuring out for a long time. And in other contexts, we also look to the elements of the claim and the nature of the claim itself relating to or arising from the certain fact or circumstance. Choice of law, statute of limitations. Does the claim arise from contractual injuries or tortious injuries? Does the claim arise from a negligent design versus a negligent maintenance? These can implicate different statutes, and the focus is on the elements. And I think that focus on the elements is supported by the statutory approach. With the statutory illustrative examples, each one, the elements are proven with direct reference to COVID. And just to say that it must be related just because that's why she was on the premises just opens up a whole universe of claims that have nothing to do with the coronavirus. And if a claim doesn't arise from or relate to the coronavirus or to the hospital's response thereto, it should not be covered. And this fits with.
Wait, I want to push back briefly just on your statutory interpretation argument. Doesn't this situation seem like exactly the type of situation that this act was designed to address? I mean, you've got here, Flowers had to make some operational adjustments because of COVID in order to provide COVID patients with their own entrance to the hospital. And because, according to your allegations, that entrance wasn't 100% up to snuff, your client was injured. But wasn't the point of the ACIA, the act, to protect healthcare providers who had to make these sorts of difficult calls? Looking at the statutory scheme as a whole.
Within the statutory scheme as a whole, I'd say that they went out of their way to say you still have to comply with applicable public health guidance. And they also went out of their way to specifically address these types of claims in 793, but not in 792 or 794. And so I'd say it's clear from their intent. And I want to read from the legislative history cited in their petition at page 4. In March of 2020, State Senator Arthur Orr drafted a bill that would have provided immunity for business entities from damages claimed by individuals who allege they contracted the coronavirus while on the premises. Senator Orr stated, if a business chooses to remain open in these desperate days, it is fearful of potential lawsuits based on COVID-19. This bill seeks to address that fear. And it's clear from the legislative history and from the wording of the statute that that's what they were focused on. The entire subsection A only focuses on exposures or contractions of the virus. And, pulling this otherwise related to clause out of subsection A distorts the meaning and destroys the contextual harmony of the statute. Related to either or both of the following: subsection A, contractions or exposures, and subsection B, efforts related to the efforts to stop or delay the spread of the virus, testing, PPE, contact tracing.
Let me ask you another hypothetical, since we're trying to figure this piece out. What if she had slipped in, while she's in the infusion clinic, in some water that was standing on the ground? It's dirty. It's clearly been there for a while, but because they have no staff to be able to clean that up because they're so stretched, so thin, do you think that would be something under this, or is that a traditional premises liability claim that would not be covered?
Well, I think if it's something that happened during the performance or provision of treatment, like in your hypothetical, they would have a much better argument about 794 applying.
Okay, well, right after the treatment's done and she's on her way out the door, but she slips in the water that they can't clean up because they don't have enough people.
Well, certainly that one condition precedent to them getting that immunity would be showing that that's a reason why this happened, was they were negatively affected by a lack of resources due to the pandemic. And then also they're required, again, to qualify for this immunity, they must comply with applicable public health guidance.
But isn't that the problem, is it's been struck? This defense has been struck, so now they're not even going to be able to raise that under this judge's ruling. So all these evidentiary things, how's that going to work because that defense has been struck?
Well, for one, that it wasn't in their response to the motion to strike, and as far as the ability to raise that, I would think they would be raising that and arguing that in the response to the motion to strike. But they're not being. I don't think they're being deprived of any ability to make a showing in that regard. And so far they haven't. They haven't attempted to make any kind of showing in that regard that they should be entitled to immunity for that reason. And again, I go back to this. The legislature could have said, hospitals are going to be strained by the pandemic, and we just shouldn't have premises liability on the premises, or at least not for patients who are there seeking COVID treatment. But they also could have said what they said in 793. They could have specifically addressed premises liability and laid out a specific procedure of proof for showing that they didn't meet that applicable public health guidance.
Wouldn't you agree premise liability is a claim, and then you've got the statute that says any claim? And also, I just want to be clear, there's no challenge to the statute being overly broad. Is that correct?
As applied to, that's correct. In this case, there's no overbroad challenge. That's right. And so, yeah, any claim, but only any claim that arises from or is related to coronavirus. I mean, I understand that's broad, but it is a limitation. The claim has to relate to the virus. And so if there's no causal relation there, if the only relation is you were there for treatment, but the injury and the claim is all about a hazardous ramp that's been there for a decade, then it doesn't arise from or relate to the coronavirus. And so we say it would not meet that definition, even though it is a claim. Flowers asserts immunity due to its actions taken in response to the pandemic, but it's got to show a causal connection between those actions and the claim itself. And our claim is for breaches of their duty as a landowner, which far predate the pandemic.
And if I'm correct, and correct me if I'm wrong, there had been some construction, correct, at Flowers, but this ramp was not involved in any of the construction or remodeling? Or did I read that
I think the only construction reference is when the ramp was originally built in 2014. But at the time, I'm not aware of any construction that was going on. Yes, ma'am. And I think here's the best way you can see that our claim does not arise from or relate to the coronavirus. You could strike all references of coronavirus or the infusion clinic or anything to do with the virus in limine and have zero effect on the presentation of our case in chief. And that's because our claim has nothing to do with the infusion clinic.
You ended right when the red light came on.
Thank you.
Thank you, Mr. Whaley.
Yeah, gold star.
Mr. Haddon?
I'd like to address kind of a question from Justice Mitchell and from Justice Sellers, and that is with respect to can you grant mandamus on this case, and what about striking an affirmative defense? Well, in this court's statement about what is proper for mandamus, ex parte Ocwen National Bank, it goes through several categories of cases for which mandamus is appropriate. It says attorney-client privilege, for example. It talks about excessive or burdensome discovery, for example. And in both of those cases, the overlying litigation would continue to move forward. But the last category it talks about is striking an affirmative defense. That is what has happened here. We have an affirmative defense that has been struck. We don't have an opportunity to argue it at summary judgment. We don't have an opportunity to argue it at trial. Perhaps they will come up with some new facts. Perhaps they can beat us in the trial court on that. But right now, with the undisputed facts on the record, we have been deprived of our opportunity, and this court's binding precedent says if you have an affirmative defense that is struck, you get to come up on mandamus. Now, we said that, I believe, in U.S. v. Gypsum on page 3 of our petition. We mentioned that striking affirmative defenses is a way to get for mandamus. And now I'd like to argue or address a couple of statutory construction points my colleague made. First of all, he talks about on premises or not. If you look at the last line of 791A13A, it talks about on or off premises. So it covers both. Okay. There was one version of Senator Orr's bill that only dealt with premises liability, but that's not this case. All right. And second, he argues that A, and of course we don't have to even get to A, little a. We're up here and arises from or related to, and we're very comfortable there. But in A, he wants to read that to say that the first part, the exposure or contraction of coronavirus, governs the whole A, that the or otherwise related to isn't a new category of operations, products, and services, is not another category that this immunity applies to. And I think that in addition to the plain language or otherwise related to, I think if we were still under the executive order of the governor, I would concede the issue. Because under the executive order of the governor on May 8th, 2020, in subsection B5 of that order, let me read you the different language that Governor Ivey used. She said, coronavirus transmission is the feared exposure to or contraction of COVID-19 infection while a business, healthcare, or provider is engaged in any business activity. So there's an express connection of the exposure or the contraction to the business activity. It was just one category. But the legislature used different words. The legislature took out while engaged in the activity and inserted the words or otherwise related to or arising from. Different words have a different meaning. And we would suggest, Your Honor, that we fall under little a, the second part, because it's clearly operations. You're running a hospital, you're routing patients into and out of your hospital. You can't perform services on them if you don't do that. So we think we're under little a, but we also think we're under the good old tried and true language of any claim that arises from or related to coronavirus. Okay, that's a transaction. We think we arise from it because they directed her through the door because she had coronavirus. She was there because she had coronavirus. She was getting coronavirus treatment. She had just gotten the treatment and was directed through that door to that defect by Flowers Hospital, and that's their claim. Now, you have to, out of the facts, the claim arises. Okay, without facts, they could have no claim. And these facts say coronavirus for the visit, coronavirus for the treatment, coronavirus direction to the door. All of those for the purpose of coronavirus. And we believe, Your Honor, that's about as arising from as related to as you can get. If there are no further questions, I'll sit down.
Thank you, Mr. Haddon. And I failed to state this at the outset. We have two justices who are not with us right now. One is recused, but the other was just unable to be with us today and will watch the DVD of the OA so he can participate in our deliberations. And with that, we thank you, and we now stand adjourned.